Hello, everyone. I'm Dr. Lou Marciani, the Director of the Innovation Institute for Fan Experience. Welcome to today's Town Hall event, Incident Reporting and Litigation from the Venue to the Courthouse. The IIFX Distinguished Fellows had recommended to the Institute to host a town hall on this extremely critical industry issue. We are glad to feature a distinguished panel of sports and entertainment industry litigation experts to assist us to better understand how to better manage the potential litigation that may result in your program. We have received over 80 questions from the panel today, and we invite our guests today to ask questions yourself. You'll find a Q&A button at the bottom of your screen. Please feel free to submit your questions to our guests. First of all, we'd like to thank Bill and the panel for spending their time and effort to organize this town hall, and to all of you out there globally coming into this town hall session. Our moderator today is Bill Squires, owner of Right Stuff Consulting, and I've known Bill over 16 years or more. And he brings to our industry experience, knowledge, and expertise in this industry. Matter of fact, Bill has been engaged in over 60 litigation cases in our industry. So, Bill, I'm honored to turn this town hall over to you, and looking forward to the town hall. Bill.
All right, Lou, thank you very much. Bill Squires, owner of the Right Stuff Consulting, operations consultant for New York Football Giants. And I do numerous other things. Never sought a role in becoming an expert witness in lawsuits, but back in 2008, I was asked to participate, did so, and here I am many years later with about 60 lawsuits, most of which involve sports and entertainment venues. I think there'll be a lot of good information shared today. The two people I'm going to introduce you to, I've worked with on numerous lawsuits, and they've pretty much educated me on how the system works. But first of all, I'd like to introduce Carla Varriale-Barker, who is actually a professor or adjunct professor at Columbia University, as am I, in the graduate program. Carla?
Hi there. Good morning, everyone. Nice to be here with you.
And Carla, little background. What's your specialty in law?
Well, I specialize in baseball, and I do a lot having to do with music and entertainment venues of all sizes as well.
Thank you. And Mr. John Pitblado.
Thanks, Bill, and thanks all for having me here this morning. I'm at Carlton Fields in our Hartford office, and I do work in this area, in particular for entertainment industry, most of the major venues here in Connecticut, as well as I do a lot of work for colleges and universities and their sports-related litigation. We, as a firm, do the similar litigation in several of our other offices: Atlanta, Tampa, Miami, LA, et cetera.
Well, let's get into it right away. I think the first thing I would like to see my attorneys here discuss is discovery. I think it's an important topic because I'm not sure that the listeners out there understand when a lawsuit takes place and the amount of discovery and what can be discovered, how critical it is to a case. So, John or Carla, Carla, why don't you start off, Carla?
Sure. I think it's important to note that there is nobody at the courthouse steps who tells you a case is worthy or not of coming into the courthouse. So it's easy to get in the courthouse, but discovery is where the rubber meets the road. Discovery makes or breaks a case. And I'm sure John will echo me when I say that when it comes time to move, to throw the case out of court, or to position the case for a potential trial, our course is charted during discovery. John, do you agree?
Yeah, absolutely. And I will say, along those lines, one of there's sort of two key aspects of discovery, and that's written discovery and depositions. And that's exactly right. What we what we present in terms of our written discovery, which would mean our incident report is often one of the key documents, and we're going to talk quite a lot about that today. Video surveillance footage, body cam footage, other documents, event staff listing, things like that. How we present those things can be absolutely critical. And then depositions are the other key piece of discovery, and a well-prepared deponent, a well-prepared witness who gives straightforward, credible testimony in a deposition can be absolutely critical, not only for putting the best foot forward and being prepared for a trial, but in some cases, if we're very clear, if we have clear incident reporting and the facts are clear, cases can be thrown out at the summary judgment stage. So we look at this discovery, like Carla said, as an absolutely critical component of, like she said, where the rubber meets the road.
Yeah, and so some of the other that I've seen when I'm reviewing case material, I mean, I get everything from depositions to complaints to I see emails, I see text messages, I see everything, and it's you just have to understand that everything is discoverable if it's been recorded or if it's been written. The plaintiff's attorneys are going to request that information, and some of that can be fairly harmful. I worked on a lawsuit several years ago where they actually went back 10 years in their capital budget and their budgeting, staffing. You know, how many people, what was it, what were they paying them? Did they increase their staffing over the years? So it's, I mean, it gets pretty detailed. Depositions. I mean, I certainly know what depositions are, but I've gone through them numerous times. But if Carl and John, you can just explain deposition, what takes place and how that works.
Sure. Depositions, first of all, it's sworn testimony. So it is a vehicle to obtain admissions about the facts of a case, about procedures, about policies. The witness's background can be delved into, and that includes whether you're a corporate witness, boots on the ground operations witness, and depositions become part of the record and the foundation upon which you can either move for summary judgment, or at the time of trial, if a witness is unavailable, for example, here in New York, the deposition can be read into the record. If you have a person who was your employee who's no longer in your employ and you weren't able to subpoena them for trial, for example, that deposition could be read into the record as if that person was present. Another great example of why depositions are so important. Depositions can also be used for impeachment purposes. And I think Professor Squires might be able to talk to us a bit about impeachment at trial or at a deposition. But your testimony, even in another case or proceeding, can be used against you in a further proceeding or in a different proceeding. So this record is your integrity. It is vitally important. And if an attorney tells you that they want to prepare you that same day, run in the opposite direction. That is not the time for you to be prepared or for your people to be prepared. I like to do it a few days before, so it's still fresh in the witness's recollection. And also, I think it's human nature that sometimes we have, when it's marinating in your mind, you might think about questions you might have or further information. It's really not proper to do it the day of, yet many attorneys try and squeak by doing it that way. I would not recommend that. John, how about you?
Yeah, no, we actually have a pretty strict rule that we follow here. We want multiple prep sessions. We like to have a prep session early on, even if it's informal, as part of the investigatory phase, just learning who the folks are, who's going to be testifying, how they present themselves. Then we like to have a formal depo prep session number one, maybe a couple weeks to a month before the deposition, and then another one, like you said, a couple days before as a refresher. But yeah, if you've got a lawyer who's saying, yeah, come on in an hour before the deposition, it's no problem that, Exactly, run and hide. Yeah, you're sick that day. There are depositions can be moved. They can be postponed almost always. That is a bad sign if your lawyer's telling you that. So yeah, prep is key, because like Carla said, you could potentially be on the stand in a trial someday, Perry Mason style, and somebody saying, well, you just told us X, but do you remember sitting in my law office 9 months ago and you told us Y under oath? Do you remember that? And no, I don't remember that. And well, do you remember things better now than you did 9 months ago, et cetera? So preparation is so critical. You really get one shot at this. Well, with a caveat, I will say, we also use our opportunity to correct mistakes on the record. Once you take a deposition, you're given the opportunity to read through it and correct any errors. So you can do a little bit of correction there, but for the most part, it's your one shot. Make sure you're well prepared, because this is going to become, for better or for worse, baked in as the story.
Yeah, and as an expert witness, I treat a deposition as like the final exam. I mean, the amount of time I prepare to answer questions, and I'm pretty seasoned at it now, but I've done it quite often. So I know what they're going to be. I pretty much know before I go in what they're going to be asking me. And there's three things that I've learned over the years of doing this, is that when it comes to lawsuits, involving sports and entertainment venues, the three things I know that I better be strong and I better have good answers for is what the hiring practices are, how they train, how staff are trained, and how the building is staffed. And John and Carla, if we could just kind of talk about that a little bit, about how the plaintiff's attorney is going to try to punch holes into how a venue is managed in those three areas.
Yeah, this is going to be my recurring theme throughout this presentation. It applies to depositions, it applies to incident reports, but everything you say can and will be used against you. Plaintiffs' lawyers will be creative, and they will come up with all kinds of theories as to why the injuries that occurred with their client are somehow the fault of the venue or the security company. So we typically see in a run-of-the-mill, altercation, negligent security type lawsuit, those types of allegations. So they'll say you didn't have enough personnel. There was negligence in staffing, and they'll cite the NFPA ratio of 250 to 1 of trained crowd managers, right? And Bill's going to talk about that in a minute, what trained means and why that's really important. They'll say you negligently failed to account for areas of your venue that are hot spots based on prior incidents, and you didn't deploy or place the personnel you have in the right places. And they'll say you were negligent in planning for this. You didn't account for the fact that this is a country music show, which is a different experience than a Kenny G show, or you failed to account for this is a hot rivalry, Yankees versus Red Sox, versus a less amped up type of event. So negligent planning, you'll see those allegations, but being prepared for those questions and addressing them allegation by allegation in your prep, so that when Bill goes into a deposition, he can address each one of those. No, we didn't negligently staff. Our ratio was 185 to 1. Well, in excess of the NFPA standard your expert is citing. And no, we don't have a duty to be in all places at all times. We reasonably had security in the correct places in areas where we thought roving teams would be effective. We had that. So if you've got somebody coming in, especially somebody with the background like Bill's, who's going to address each one of those and show why that allegation is, for lack of a better, BS. That sort of preparation in a depot like that can really put a case to bed. Either it'll settle very quickly for very little, maybe it'll get dismissed on summary judgment, or at the very least, if you have somebody who wants to play chicken on the other side, you'll be armed to the teeth at trial.
Carla.
Well, I think that the most frequent claims I see are failure to train, failure to adequately staff or anticipate the potential problem, whether it is a maintenance issue, a security issue, or otherwise. Those are the areas where I think the vulnerability is, or where an adversary will try to burrow into. And my experience is the more you're able to document your policies and procedures, the fact that you are a responsive venue or responsive venue operator, the better chance you have of getting through a case unscathed.
Yeah, and I've seen, I mean, documentation is absolutely critical. And if you're going to do training, and I've been asked this question many times, like, okay, so they trained. How do you know that they received and understood the training? Were they tested? You know, if testing is not involved, then how do you know that the individual actually learned the material? So I think it's important. You know, you need, and I've seen training in so many different lawsuits. I've seen good documentation and poor documentation. I know we have a lot of people on this call from all over the country, and there's, you know, some states require a guard card, and that training is extremely important. And the fact that they're current in their training. So being able to document training and have training will certainly help me and any other expert in this, you know, defend a lawsuit. And I agree with John wholeheartedly that, you know, one of the things I pretty much say, you know, is that you have to do what you can to reasonably staff the building. And I believe most do, without question. But, you know, security can't be everywhere all the time. But we have to make that reasonable effort to have the proper number. They were hired properly, they were trained properly, and they were, you know, putting them in a location that was certainly necessary. Hang on a second. Negligent planning. You know, it's they will talk about did you do, you know, threat analysis? Did you do any type of John alluded to it earlier, but you know, what concerts coming in? Did you advance the concert? Do you have a rivalry game coming in? What did you plan? What did you do differently? But that a threat analysis will always come up. As far as negligent planning, anything that John or Carla you'd like to comment on?
You know, I mean, go ahead, Carla.
I was going to say this goes right to this concept of foreseeability, which is one of the ways that liability can be placed on a venue owner or operator. Was this event foreseeable in the reasonable exercise of your duties as a proprietor, owner, operator of a venue? And foreseeability is very fact intensive, which will highlight some of the themes we have today. Did you have notice of prior similar incidents or complaints? Were you not agile in responding to that knowledge? What did you do to ramp up or to address the potential threat? Totally critical issues. Again, from our point of view, John, we are always trying to get the case dismissed by a judge, dismissed as a question of law, not dueling facts. The more information I can provide about how industry standards were met, no local, you know, God forbid, fire code, building code were violated, over service of alcohol or an illegal sale of alcohol, the more I can demonstrate that those things are not an issue, the better chance the owner, operator, the venue has of getting out of a case unscathed.
Yeah, and I was gonna say, in terms of planning, claims of negligent planning, I like to be able to point to meetings with local law enforcement. Oftentimes, you know, if you've got a good ally in your local PD, and most, you know, large events do and have to, you've got to hire them, frankly, for parking and for inside help, for that matter. But showing, yeah, we have a strong relationship with local law enforcement. We have uniformed police visible outside the entrances. We have uniformed police visible inside the stadium. And we sit down with the chief, you know, a week before, and here's what's expected. Here's the numbers we've got that we're looking at. Those, you know, if you can point to that type of planning, those things, that's a great defense to claims of negligent planning. And you know, I will say too, we've seen clever plaintiffs' counsel, you know, sift through arrest records, right? Okay, well, then explain how come there were 65 arrests the last time this show came to town and you didn't account for that. And then you start to parse the data, and while those arrests did not occur on our property, they were 3 blocks down in a parking lot that was not controlled by us. Has nothing to do with our venue, and frankly, you can, if you really do a deep dive, you'll probably find that a spectator is safer inside your venue on any given Sunday than they are at their local bar near their house on a per patron, a criminal violation type record basis. So, there are, keep drilling down. Undisputed facts are our friend, and they can often refute some of these very clever plaintiffs who do their own digging. But don't be afraid of that. And again, that's where our work is so important in discovery and building up that sort of rock solid defense to all these claims that plaintiffs counsel, and they're constantly creative. They're always trying to come up with new theories, but good planning, good relationship with local law enforcement. These things go a long way. They're good atmospherics too. People, jurors, want to hear that. They want to feel, boy, I always felt safe in when I went to a game or a concert. I never experienced what these people are saying is the mayhem that they put in their complaint.
So listen, I've got a couple questions here. Okay, getting off my track a little bit, but Kevin Williams, who sounds like he might have a little bit of a legal background. The question is, and this is for you and John and Carla. Can you explain an owner's, operator rights based on the legal statuses of non-delegable duty?
Yeah, I'm happy to jump on that one, Carla. I deal with that a lot.
Sure.
The property owner, and this doctrine is applicable in Connecticut. It may or may not be applicable in any given state. That is one issue that we should highlight. Unfortunately, we live in a federalist society, and we have 50 different state laws oftentimes, but this is a pretty typical one. Even if I own the property and I have contracted out the security function to some other company, I can't just say, well, whatever they did is on them. No, actually, everyone you hire for your venue, your alcohol vendor, your security subcontractor, your outside maintenance staff, you're ultimately responsible for all of them. That is a non-delegable duty. So that raises a really important issue about your contracts with those parties, right? Because while you can't delegate the duty by contract, right, you still have the duty. What you can delegate by contract is who's got to pay for it. And that's called an indemnity provision. So you want to make sure you have a hard look at all your vendor contracts, and same with if you're a vendor, if you're a security vendor, well, are they pinning everything on me? And do I have to pay for everything that comes out of any litigation at this venue, even if it wasn't our guys? That there's a lot of scrambling behind the scenes, between co-defendants, and I hate it. I never want to see co-defendants battling. We're just doing plaintiff's work in those cases, but the best defense against the non-delegable duty doctrine for the premises owner or lessor, whoever runs the property, is good indemnity provisions, and so all parties know what their lane is, and their insurer knows what they're responsible for, and that stuff gets worked out quietly behind the scenes among defendants. Don't have battles between each other and pointing the finger at each other. You're doing the plaintiff's work, and you're driving up the value of the claim.
And let me add, since you used the I word, indemnity, I'm going to use the other I word, insurance. And you might also, as the venue owner operator, have insurance rights, in additional insured coverage. I hope that you do. I hope your insurance broker is your friend so that you've got that sort of thing sewn up, Kevin. But those are your friends in the face of a non-delegable statutory duty. And while we're on the subject of indemnity, let me raise an issue that as a lawyer makes me crazy. And John, I'm going to guess it makes you crazy as well. the reciprocal indemnity provision, whereby everybody in a contract says that they're going to play nice with each other and you'll only be responsible if you're negligent, and I'll only be responsible if I'm negligent, and that's when the indemnity will be triggered, invariably makes for more problems and more litigation. I hate the reciprocal indemnity agreements. I understand why on the business side you want to use that because it's everybody playing nice, but in the real world or in the litigation world, should you get to it, it makes things so much more complicated. John, do you share my fear and loathing of the reciprocal indemnity?
I do, and we're messy in this industry in that regard. I wish we were a little more like the construction industry is a great example. Indemnity is supposed to, quote, flow downstream, right? So your downstream partners should be indemnifying you for anything arising out of their work. And those contracts tend to be pretty clear and uniform. They're not so clear and uniform in our space, and it drives me absolutely crazy, Carla. And it's a very similar issue as the mutual other insurance provisions, which basically leaves the two insurers saying, well, no, under this other insurance provision, it's you guys. And so you've got two insurers fighting behind the scenes. You got two parties fighting behind the scenes. And meanwhile, the plaintiff's counsel is on vacation in Hawaii, loving life and coming back to a trial where you guys have made his case for him.
Right. So, Kevin, I hope this answered your question about some ways to get around the non-delegable duty. I have it here in New York, and I agree with John. The strategy is always trying to find avenues to shift it off of your shoulders and onto, let's say, a contractor's. But the way to do that is through the sort of indemnity and insurance provisions that we're talking about here. As a building owner, if there is, let's say, a fire code or a building code violation, I'm not going to be able to shift that for you. So that's the sort of non-delegable duty that makes us concerned. Safe means of ingress and egress. Maybe we can argue about security and crowd control. Alcohol, selling alcohol, maybe we can shift it if you've got a concessionaire. But for the most part, your insurance broker should be part of your risk management team and helping you find a way out of the non-delegable duty to the extent you legally can. Good questions. I love this.
Yeah, I've got a question from my good friend Kelly Way. And I think I could probably answer this for Kelly, but I'll give you guys a shot. Should an emergency operations plan be high-level emergency response or more detailed to the responses specific to an incident, i.e. active shooter, severe weather, fire, etc.? So I'm going to be taking my first shot at it because I've seen so many emergency operations plans, emergency action plans when reviewing case material for lawsuits. And I would tell you, you want to cover everything. I know of a document, emergency action plan, it's about 275 pages long. Excuse me. I mean, there's a lot of maps, a lot of charts, but it covers about 36 different actions, and it could be anything from severe weather to loss of power to flooding to a disabled, a fuel spill on a roadway near a building. So I think you really need to consider everything possible. And that not only goes with your operations plan, but your event plan for that upcoming event, that risk management, that threat analysis, your staffing plans, all of that is vital. And, when I see a document, and there's one specific venue in the country that I've worked on a couple of lawsuits, they have an event plan that's like about 80 pages. And it's really easy to go through that and defend this venue because of the amount of detail. And they include all the stakeholders to develop these documents. It's not just one person sitting in an office. So it's the venue, the team, your third-party contractors, your legal department. Everybody should get a shot at looking at this to make sure it encompasses everything you could possibly think of. Anything to add, John or Carla?
You make a great point there, Bill, because the buy-in that you have from your other stakeholders beforehand is just going to mean a lot less finger pointing afterwards. And again, it's when we're all, the folks who are putting on the event start pointing fingers at each other, when something happens, you're doing the plaintiff's work. So yeah, if you have buy-in from local law enforcement, they had some opportunity to have input, et cetera. They're not going to be coming after, and jumping on the press, when something bad happens and says, well, if they had just, had heard us out, we could have told them, well, so hear them out beforehand. That's the time to do it. And I see there's a corollary follow-up question there, Bill, that probably would be good for you. How often should an emergency operations plan be updated? They're muted, Bill.
Yeah, I know that's from my good friend Hassan from Ottawa. I think it should be reviewed every year. But if something were to happen, for example, we're starting to see these protests throughout the country, animal rights, and 2 women a couple weeks ago ran on the field, SoFi Stadium, during the game. That may not have been covered in your emergency operations plan or your event planning. Now it needs to be added to the plan. What are you going to do? So I think it ought to be a formal review done every year. But if something happens that's not included in that plan, it should be included in the plan. I hope that answers your question, Hassan. No, I want to talk about contracts if we could, because I've seen, and once again, I get to see contracts for every third-party partner out there, and there are a lot of contracts that tell a third-party partner, you got to do this, you got to do this, you got to do this, and it's good stuff. But the question is the venue following up on whether or not that contractor is carrying out the duties and responsibilities that the venue is asking for. So could you guys talk a little bit about contracts?
Yeah,
John, I'll let you go.
That's a great point, Bill, because all the best intentions and careful drafting, spelling out specific duties and things can frankly be undone if that's not how you actually operate in practice. Your contract might say, well, X company is taking on the duty to do 1, 2, 3. But if in practice, you, the venue operator, you've got guys jumping in and helping out, or maybe even taking over that role, they in this, again, should be behind the scenes when you've got, co-defendants generally is how these folks are postured. Do this behind the scenes. But you may well in practice undo what your lawyers carefully set up in drafting the contract in the first place. That's something to keep in mind. I'll just say another contract provision that could be really helpful on the idea that I keep hammering. We don't want co-defendants fighting out in public. Do it behind the scenes is arbitration. Sometimes there are intractable disputes between stakeholders, and they need to resolve it, but they don't want to do it publicly. Arbitration is a great option. It's cheaper, and generally when you have 2 commercial entities, they're going to be amenable to doing that. They don't want the public to see these fights, and that can be done completely out of the view of the plaintiff, out of the view of the public. Resolve your stuff. Resolve whose duty is what. But again, keep in mind, you can kind of undo with how you operate in practice what was set up, and as the intended practice in the documents. So that's exactly right, Bill.
Let me add something to that. I like arbitration. I don't love arbitration. What I don't love about arbitration is it is more expensive than, let's say, a non-binding mediation. Both of them can keep disputes out of a public realm. They're not publicly filed. Arbitration also is final. No appeal from that. I like that mediation is an off-ramp. If I don't agree with the mediator, or if it doesn't go my way, I can walk away and start fresh. Arbitration, absent fraud or some sort of misconduct by the arbitrator, you're done. And you've got to be prepared to live with that. So I like it because it is an off-ramp and a way to resolve disputes. It's a little more money than something like mediation, but I'm somebody who likes to have an avenue of appeal if I don't agree with it. So people should just be aware Arbitration is final, it's binding, and if you don't agree with the arbitrator, you're going to have to live with it.
And your contracts are discoverable, right? So, and that's going to be a source of establishing duties by the plaintiff. They're going to say, well, there might not be a general duty under the law to XYZ, but you've undertaken that duty by contract here. Explain exactly how and what you've done in fulfilling that duty, because it looks like you didn't. And all of a sudden, they've got a nice setup. So if you've got duties in your contract, you make sure to fulfill them and look at your contracts and go through them with your managers and make sure everybody's doing what they're supposed to be doing, because those do kind of set the table for a plaintiff in litigation.
Yeah, and I've seen that. That's why I brought it up, where a third party was supposed to do something and they didn't do it. And fortunately, it got settled before I had to go through a deposition, because there's no way I was going to be able to defend that. There was just no way I was going to be able to defend it. And excuse me, but let's talk about incident reporting. I think that's the title of this meeting. And you know, I've seen so many different incident reports, and I've seen so many mistakes made in incident reports, and it's something we rely on heavily when we go into a lawsuit. So I'm going to add my 2 cents worth after John and Carla add their 2 cents worth. Carla.
Incident reports, another thing that can make or break a case. For some of my venue clients, they actually have the affected person reporting the incident sign it, meaning not just the employee or agent of the venue who was on site, but the person who is actually making the complaint was injured. And I've been able to use that at depositions later. It's very valuable.
Yeah, these are not document heavy cases. Sometimes that's the only document in the case. You know, there are a few others usually, but it's definitely a key document. It's sometimes the only document. These are not like million-page discovery type cases where you got to hire a team of document review pros to go through stuff. So you're looking at one page, and that's you know, kind of everything. So it's a critical document. You know, so making sure that your frontline folks are filling those out in the way that the form is set up to be filled out, right? So you often have pre-filled forms with boxes that you check. Okay, what type of incident was it? Was it a theft? It was an altercation. It was a slip and fall. There's another box for what section of the venue was it in? It was in section 600 or section EE, you know, row whatever. You know, if there are boxes to fill out, they need to be filled out, even if it's just to say not applicable. You know, and accuracy, I'll say this again and again, accuracy. You know, if you think, well, it sort of doesn't matter what time it was, blah, 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 and that's sort of irrelevant to what happened here. I'll just put something down there. If you're wrong about some little, what you think is minor or irrelevant detail, you're throwing into question your credibility on the other boxes and the things that you thought were important that you put a lot of thought into. So accuracy is critical. And one of my big themes today too is no opinions, only facts. Just record the facts, just the facts, ma'am. You know, because if you get into opinion land, boy, we really should have had more guys over there. You know, it really seems like the plaintiff really was injured badly. You're not a doctor. You know, was there, you know, they were complaining of this, fine, those are facts. They said this, fine. They exhibited these signs of possible intoxication, but no opinions. You know, stay away from putting any type of opinion in there. And I will also say, if there's a report form and you should be filling out incident reports and use incident reports, use just that. Don't supplement it with texts, you know, to your manager later. Oh, you know, I wanted to add, you know, my thoughts on this. I text my GM offline or something, or send an email after the fact. Oh, I wanted to add some details and my thoughts on. No, put it goes in the incident report. It's a business record. Record it to the best of your ability. with just the facts, no opinions. And that should be the only document, right? Because they're going to find those texts. Those emails are going to get discovered. So don't send them. You phone calls are great too, by the way. I always prefer folks calling each other on the phone versus sending text and emails to talk stuff through first.
This is a great point about training and orientation of your events staff. What John just said is so valuable. In our world, when we deal with a lawsuit, what is said, it could come in as a business record, but those can also be admissions. A number of times, I think I've worked with event staff that have meant to convey empathy, being fan-friendly in a way that they talk about what happened to the fan. And it winds up being an admission against interest on the venue owner. Oh, that's happened so many times here. That shouldn't have happened. Something like that, or that's always there, meaning a condition, or I told them they needed to have more staff in this area. Incredibly damaging. And that is a training and orientation failure as much as an incident report. So what this event staff verbally says can bind their employer as an admission, and the record itself could be a business record that comes into evidence.
Yeah, accuracy and truthfulness too, for gosh sakes, if you're wearing a body cam and your body cam is got a video of one thing and you're saying another thing in your incident report, that's going to be a major problem. So yeah, everything that Carla just said. I do see a question here.
Well, let me finish up on incident reports, okay? There should not be, if you have a third-party vendor providing security services and they have an incident report, the venue should not have an incident report. There should be one incident report. There should be a police report, a medical report, and an incident report, and there shouldn't be multiple versions of those. I worked on a lawsuit.
What if there is, let's say, an overall computer database that the venue operates? How do you then harmonize the vendor, let's say it's a security person, with the fact that that is probably logged into the venue's own system? Help us to work through that issue and avoid conflicts.
Yeah, well, there is an incident tracking system that I think that most venues do use, and it does detail, and it provides detail of what the incident was, who was involved, where it happened. But I think people still walk around with incident cards in their pockets, just so they can record any incidents, before they maybe, contact the command center. But once again, all that's discoverable.
Yeah.
Yep. And I think I said earlier, I know some venues that if nothing happened in their seating section that day, they write down nothing happened. Another thing is legibility. There's a lot of people that just don't. Like for me, for example, I'm lefty. My handwriting's I can't even read it sometimes. And I think when somebody writes an incident report card and they turn it in, before they just let the person go, they should read it to make sure it contains all the information, to make sure it is legible. And if it's not legible, somebody else should write it, make sure that they agree to what is written, and then sign it. But I've seen so many times, no dates, no signature. I've seen incident reports filed 2 months after the incident happened because they forgot to do it, and then, or the venue came back and said, hey, you got to file an incident report card. That doesn't work when it's 2 months later. But I think it's really, really, I've been involved in a lawsuit where I had to go review like 2,000 different incident report cards for like 5 years. And you can just tell what the plaintiff's attorneys are doing. They're going through every single one of those cards looking for, to see if they're complying with the rules. So I agree, Carla, orientation and training and refresher training. Don't do it just one time. I mean, you can do it 15 minutes before you open the gates. You can go through a quick training session on anything. And I think incident reporting is one of those. So there is a question here. I'm sorry, for Eugene Posey. What would be the procedure if a staff member was allegedly accused of an assault after they clocked out of work and incident occurred off-site? That's not me.
I'm reading it, and I've got all the worry questions popping up into my mind. Okay, well, they it was off-site. They had clocked out. Those are good facts in terms of the liability of the venue. But were they doing an errand? Were they going to pick up more hot dogs? Were they, because your employee's agency on your behalf doesn't always neatly end, the second they walk out the stadium and are onto a public street, or the second they clock out. But I mean, generally, in this example, look, what your employees do on their time out of their uniform is on them, as a general matter, but it's not always so neat, and it might implicate, well, geez, yeah, okay, well, they weren't on site, but you hired them and you didn't look into their background. They had 17 assaults on a rap sheet on their, why'd you hire them in the first place? Why were they even in your venue? That sort of thing. So never underestimate the creativity of a plaintiff's counsel, especially with a serious incident like this. You'd hate to have it imputed back to you. And I'll say that, an assault is an intentional act. That's another issue. It implicates your insurance coverage. You might not have insurance coverage for an incident like this. So it's a serious issue.
Right. So there's agency law, which we touched on the answer. And is there an argument or facts that might support a conclusion that the assaulter, the assailant, was somehow still acting in furtherance of the employer's business? But if you could go back to the question, Bill, was the question about what procedures should be in place?
What would be the procedure if a staff member was allegedly accused of an assault after they clocked out of work and incident occurred on site?
Meaning procedure to investigate it, procedure, do you put that person on suspension while you investigate? Do you notify the police? I'm a little unclear about the question, but I want to make sure I respond to exactly what the concern is.
Well, I will ask.
Who's the accuser too? Is it a co-employee? Were they walking out together? Yeah. That sort of thing.
Well, and Eugene, if you would maybe clarify the question while we continue on, but let me, and Cheryl, I do see your question. I will get to it, I promise you. But before, I'm getting kind of old. If something pops in my head, I got to remember it. I got to talk, otherwise I'm going to forget it. But, I get answered quite often, or asked quite often in depositions, do I know anything about the Stadium Managers Association? Do I know anything about the International Association of Venue Managers? Do I know anything about NCS4? Do I know anything about IIFX? Do I know anything about tips training or team training? And it just so happens that I'm fully aware of all those organizations. So for those of you who may not be members of those organizations, it's something you may want to consider because they do share best practices and they do share, other information. I think that would be certainly beneficial to your venue. So that leads to this. We know I'm learning I think I almost getting my JD. I'm getting close, but when you hear duty of care, when you hear industry standards, and you hear best practices, can my friends, the attorneys here, talk about how important they could be to a lawsuit?
Critical. 100%. Need to know the industry standard, whether it was met. Critical for the defense of the case and actually critical for the operation of the venue. That's the sort of need to know information you need to know. John?
Yeah, I mean, look, often every venue is different, and every venue is going to have its own peculiar things that are specific to that venue, and there's not going to be a quote industry standard for everything. But yes, if you're a Major League Baseball club and MLB has dictated, yeah, you have to do this kind of entrancing, and you don't follow that guideline or best practice that the league that you're a part of has imposed, you're going to be held to that standard, whether you like it or not. It's going to be characterized as a quote industry standard or standard of care, and that's problematic for us to defend. It's nice to have uniformity. Again, though, we live in a federalist society, so uniformity can be difficult when Florida says no vaccines required, but New York says you're not coming anywhere near our stadium if you haven't been double vaccinated. And then your league says, well, another thing, you got to know, what are those standards? What is my general manager part of the International Association of Venue Managers? Because if he is, he's going to be held to whatever standards they promulgate. If he gets that email that, every year that says, here's our best practices guideline or whatever, he's going to be charged with knowing what they are and employing it at that venue, even despite whatever peculiar local laws or oddities of your venue layout, etc.
I mean, that's again goes to, are you in compliance with your building code, your fire code? Do you have a certificate of occupancy? Do you have violations that are issued? Any issues with illegal sale of alcohol on your premises? All of those sort of industry standard duty of care factors are something that it's incumbent on the venue to know, frankly.
Yeah, and I think that, I've been doing this for 35 years in the industry, so it helps me because I'm not only versed in, I think, the security aspect, but the guest services, groundskeeping, parking, traffic, concessions. So, and not only just NFL, but MLB, NHL, MLS. I'm pretty familiar with what they do, and if I'm not, then I certainly do my due diligence and do my research. But it always comes down to what are the best practices. And I tell you what, don't think the plaintiff's attorneys haven't been able to research what best practices are. When the NFL or MLB produces something for all teams, that becomes discoverable. I was being deposed, or I was reading case material on a lawsuit where an individual is being deposed, and they said, do you attend your league meetings? Yes. Well, did you attend a league meeting in this city on this date, which was 3 years prior? Well, I did. Do you remember going to this period where they were talking about whatever? Yeah, I was there. Well, do you remember what they talked about? And all of a sudden, I can't remember. But that's the level of detail they'll get into, because they know, these plaintiffs' attorneys, they know what they're doing. They're sharp, and they're gonna, if it's discoverable, they're gonna find it.
Well, I see we have a series of follow-ups here to keep it in town hall style. Eugene's given us a few more details that might be good for some jumping off points and further discussion on these the duties and how they can kind of spill outside the venue when your employees leave together. I guess in Eugene's example, it is 2 employees, right, of the security company, a male and a female. I'm going to guess which one is the victim and which one is the assailant, but not always gender specific in that way. What is the duty? One that I touched on earlier that I could see coming up in a case like this. Did that male employee who committed the assault, was there a reason to believe that he had that type of propensity when you hired him? Is it a negligent hiring practice? And and as Carla said, your agency may continue on, your employees, agency on your behalf may continue on even after punching out and even after leaving the property. And it is, more likely that you're going to find something like that where it's, 2 employees, both known factors to the employer. You've got duties to both. You've got duties to your victim, in terms of procedure after the fact. Because you can imagine litigation from both sides. Oh, I was falsely accused. How come you didn't check her background? She falsely accused somebody and was held liable for that once. So you can imagine, you've got major problems when they're both your employees, whether they're on the clock or in your workplace or not. Of course, your responsibility will definitely disappear or fade or be lessened, the farther away from work they are, the more clocked out they are, they're not in uniform, et cetera. But it's not always so neat. So I don't know, Carla, you may have more to say on this, given these variables that we've had added to the chat here.
Yeah, this is really like an onion. There are so many layers to peel away with this. Like Eugene, I would want to know, is there a contract? Is there an employee handbook that talks about expected behavior or what to do if there is a complaint about the employee? A duty to investigate what happened? Was law enforcement advised if it was a criminal activity? Is it a situation where the accused is an employee at will and you have the ability to terminate and not even investigate? Many nuances to your claim, but if your question, but if we're worried about a potential claim, again, I think the negligent hiring, negligent retention. Did you have reason to know about the propensity of the assaulter? And I don't want to make assumptions about the gender orientation of the alleged assaulter, but were you on notice? Was this foreseeable? Is there any argument that could be made that it was in furtherance of company business versus something that was purely for that person's gratification or criminal intent? Many extra facts needed here, Eugene, but a good question.
All right, we have another question from Cheryl Pickney Moss. The question is, what do you think about technologies that allow fans or customers to report incidents directly to security via an app? How are venues accepting those types of technologies? And I can begin. I'll address that. You know, the text messaging system at venues has been in existence for quite some time now. I'd say at least 10 plus years, where, you know, there's a little sign up there somewhere on the facade of the building that says, hey, if you experience some sort of an issue, please text this number and tell us what the issue is. So that's been used forever. It's actually recorded into many of these incident tracking systems. Certainly, you know, people don't want to go up and point somebody out. They're a little worried about if they do that, what the repercussions are going to be. To be honest with you, I don't. If I'm sitting at an event and people are not behaving, I'm going to go get security and I'm just going to point the guy right out. But that's me. But I do believe, yeah, you know, the fans can help. And it's not, I'll tell you what, it's not only incidents, but it's like a potential slip and falls. It's a broken handrail. It could be anything. You know, people will text Command Center MetLife Stadium, hey, where do I park? I've got this blue parking pass. What time did the train stop? When did they start? So definitely any technology to make fans feel more comfortable and, you know, having eyes in the sky, they can certainly help us maintain a better environment if they're going to report things. Certainly, Cheryl, I mean, I think that whatever technology is out there that will help identify people that are not behaving themselves is useful, and we appreciate that.
But then let's look at the flip side of this bill. That is also, that system, a vehicle for notice that you have to react to. You know, maybe not the what time the train, what time does the train leave? But if somebody's telling you there is a spill on the concourse, or a handrail is jutting out or broken, or there's a belligerent drunk guy seating level A4, that's now creating a duty for you to, within a reasonable amount of time, react to it. And what is reasonable can vary based on the facts. So it's a two-edged sword. You get the information, but then it's also creating a duty for you to react to that information. Maybe not telling the patron what time train they need to get on, but you might need to dispatch maintenance or security promptly.
Well, yeah. and that's up to our staff. Once again, it comes down to training. You know, if an usher sees a spill in a restroom, you know, report that to housekeeping to make sure it gets taken care of. You know, I'm a big believer. If you see something, say something. But that was a result of 9/11. That was all about terrorism. It's all about unattended packages. But I preach, if you see any unsafe or any situation, whether it's a terrorist, an active shooter, whether it's a belligerent drunk, or if it's a slip and fall, or if it's anything that can harm someone, it needs to be reported. But it also leaves it up to us. I get asked this question, or I see it in depositions. Did you inspect the venue before you open the gates? You know, how do you inspect the venue? If you have broken seats, how do you respond to that? Things of that nature. So you're right. You have notice, but you have to respond. And we do appreciate, we have an incident, and I'm speaking specifically at MetLife Stadium. We get a text. We immediately put one of our 751 cameras on that location to watch the person. And we can go back in time, obviously, on the video that's been recorded to find out what took place. We had an incident the other day with the Jets-Panthers game, or Giants-Panthers game. There was a spill from the upper level of beer on somebody, and automatically everybody thinks it was done on purpose. And we went back in the video, looked at it, saw it was a complete accident, and we rectified the situation. But with CCTV cameras, one of the things we also do is we can report of an incident. We put the camera on it. We actually check to see how long it takes for somebody to respond to that situation. So, keeping people safe. I tell people all the time, I think the safest place to be at 1 o'clock on a football afternoon is probably a sports facility because of all the security, law enforcement people there they have, taking care of the building. I hope that we answered that. We have anonymous attendee asking a question.
I wanted to just jump on. Cheryl had a follow-up question there too, just more generally about technology. This might be a good jumping off point to talk about surveillance video in particular that just came up in our responses, and body cam footage and preservation, particularly with surveillance footage, because I think it's pretty universal that your stadium surveillance cameras, whether manned or not, auto delete typically after about 30 days. You typically don't see claims for until after that 30-day period. But if you can capture an event or like Bill said, you have an ISS system and you're notified, now you've got your cameras trained on it. Well, it certainly behooves you to preserve that video. And so you've got to make sure that your folks who are operating that video or your manager in charge of it at the end of the night, preserves that and pulls it off the system in a way that preserves it, because a lot of times these things are subject to auto delete. And what you might have said, oh gee, I had that whole thing on video, I know it's there, I saw that claim is total BS, and I can prove it by the video. And then 20 days later it's your insurance adjuster saying, well, where send me the video that you think is so great, and oh whoops, it's been auto deleted. Keep that in mind. And on the flip side of that, if you've got video that hurts you, that's bad for you, and a plaintiff's counsel jumps in early within that 30-day period and is telling you to preserve any video, and you don't, it raises the big bad word that I'm going to let Carla talk about, because I know she'll get geeked up about spoliation and how that can be used as a weapon against a venue or defendant in litigation.
So the S word, spoliation of evidence. It is specific. It's a state law claim, so it depends on your jurisdiction. But essentially what it means is if you have some piece of evidence, it might be an incident report of notice, of surveillance footage, and you destroy it. By the way, it might also be modifying or changing the area where an accident happened. And it impacts the other side's ability to prove their claim. And again, state law variations. There can be an adverse inference. You might have your pleading stricken by the court. The preclusion of evidence regarding some of your defenses. It is serious as a heart attack. And I don't know which one of them is worse, because sometimes I think the adverse inference to the jury that like you're hiding something or you're a liar or untrustworthy is just as bad as having your pleadings stricken by the court. Do you agree with me, John?
Yeah, right. And then the other S word, sanctions. Even
oh yes, that word.
get hit with monetary sanctions, and not just the party, right? Not just the venue itself or whoever the party is, but the lawyer, the law firm, right? We can all go down the toilet together with the spoliation word. So
don't
be
do me
very
like
careful.
that.
Yeah, be careful about preserving evidence. And not to scare you too much, it's a steep standard. You have to sort of prove intentionality, but we can't stress more how careful you need to be in this space, because it's a big bad word. It creates its own litigation. It's a corollary to the main event. It's expensive even if you win. So it's something to keep in mind. But in terms of this technology, body cam footage, this is something Bill and I talked about yesterday. It's one thing when you've got the patrons who are there with their phones recording what they think is the bad acting, event staff or whatever. Well, guess what? You turn on your body cam, video, and you're doing the same thing. So if it's a he said, the patron is always right thing, but your body cam footage shows they're not right. Well, the body cam footage is gonna control. So use that technology. Sometimes just making sure that somebody knows they're on body cam footage now, that alone can de-escalate a situation. That can be helpful in terms of just overall in terms of the technology we have nowadays. It's not just frontline law enforcement anymore whose every move is being recorded by their own mounted cameras. Every person in the venue, every patron, every employee, even the manager level employees, it might well be on video, real time, and saved and preserved. So hopefully it keeps all of our behavior better. We all tend to behave better when we're on camera, and we know it. And it can be very, very helpful evidence that, I say a picture is worth 1,000 words and a video is worth 1,000 pictures. So, use your technology wisely, and preserve it, good or bad, preserve what you've got. Because if you fail to preserve the bad stuff, you might get hit with spoliation. And if you fail to preserve the good stuff, you've lost a great defense.
Yeah, well, here's a follow-up to that. Matt Bettenhausen asked a question. It's how often are you seeing plaintiffs waiting 6 months or more to file to take advantage of routine deletion of video evidence? Seen this especially where no complaint notice of supposed incident took at the time.
I'll say it's exceedingly rare to ever hear from plaintiff's counsel or get claims within the auto delete period. So it's up to you to make sure you're checking you've got what you need before it gets auto deleted. And they might strategically wait. They might well know whatever's on there ain't going to be good for me. Let's hold off on making the claim. If they talk to crafty counsel in that initial 30-day period, and they're candid with that counsel, the counsel may well know, well, all right, let's sit back and hope that it's auto deleted. I'll send them a letter on day 60 and see what they have. But it's absolutely I don't underestimate the underhandedness of plaintiff's counsel ever. Not to be biased, but I'm here to protect the venue, so I'm a true believer.
I feel like plaintiffs delay not necessarily because of a desire to outfox the video retention policy. Some of them, quite frankly, aren't sophisticated enough to know that. But people, there's with negligence in my state, there is a 3-year statute of limitations, and the number of people that are coming in just under the wire. And that, it's helpful if you are ever faced with a spoliation motion, and I've won them, because you were not put on notice of the injury, the claim, etc., the lawsuit, or that it would be needed for a lawsuit. Especially if it's been, as I've seen, as I'm sure you have, John, 2+ years until somebody decides to sue.
And that's pretty typical, that you don't see lawsuits until pretty close to the end of that statute of limitations period. And for an additional reason is that plaintiffs' counsel want to see as much medical treatment as they can in that time, right? So they're waiting for you to reach maximum medical improvement or whatever. But that's probably worth a larger point. That is, for folks who get involved in this litigation process, it's a long process, right? So you might not see the suit for 2 years after the incident itself. And you're not going to see a trial based on that complaint for probably at least a year, and oftentimes, sometimes 2 or 3 years before you get through a very lengthy discovery period with the depositions and the written discovery and fighting over spoliation and all these other things. And inevitably, trials get bumped, courts are backlogged. It can be really frustrating for folks who aren't used to our fairly, I won't say broken system, but dilapidated justice system. It's delay. There's a lot of delay. It can be really frustrating. It's another reason why it's really good to record, good facts early on when memories are fresh, because, no frontline guest services person is going to remember what the heck incident, what anybody's shirt color was on X day, 3 years ago when they're getting deposed. But you put it in your incident report and you say, well, that's, as a matter of course, I always am accurate in my incident reporting. So I'm sure whatever I said then was accurate. I don't remember independently now anything about that day.
Yeah, if I could add it, I'm sorry, Carl, but if you think that you could be sued for something, save the tape. Don't destroy it. Save it.
Yeah.
And from the time you record the incident to the time it's actually over, don't save a portion of it. Save it. Save all of it. I think that's critical. Good, Carl.
John, I wanted to piggyback on something that we were just talking about and how long people have to sue. If you are a venue that is affiliated, owned by city, state entity, there may be shorter periods of time for somebody to put the venue on notice or sue. Where I am in New York, they have 90 days to file a notice of claim. The legislature, in its infinite wisdom, gives the municipalities an early crack at discovery. They can even do a pre-suit deposition hearing of the plaintiff, but all of that is in a more compressed deadline. So you may, if you are a venue affiliated with state, city entities, have the ability to go to the city or state and say, do you have a notice of claim on this? Was a pre-suit hearing done? So that may be a way to help you gather information as well. Hopefully you have a good relationship with them.
Bill, I'd love to jump on Rob Schmidt's question here.
Yep.
And get into the some of the more frequent claim stuff we see. He says, in a post-COVID world, there seem to be a bunch of fan fights. Is there a repository of data somewhere for how much a broken nose claim costs a facility or insurer versus a sex assault versus other incidents?
Ooh.
Just looking to ballpark risk values for various incidents. So that's fascinating. I'll jump in and say one thing about fights. In my usual spiel about every American's 21st Amendment right to alcohol. We've always had alcohol. We've always had fights. We're always going to have alcohol. We're always going to have fights. So if it's not COVID that they're fighting about, if it's not Yankees, Red Sox they're fighting about, people are going to find something to fight about. We're always going to have fights. But that point now being said, this is a fun topic, Carla, right? Because what are the more expensive body parts and claims? I will say, here's a big bad word, and you can use this as a jumping off point, TBI, because it's not just a broken nose, it's a traumatic brain injury now, right? Because that person has headaches the next day, or they might have had a mild concussion. Guess what? They're all considered traumatic brain injuries, and that tends to drive claim value up a little bit.
Definitely. And once upon a time, when I first started practicing, post-traumatic stress disorder was thought of as sort of a garbage add-on to claims for injuries. Somebody was assaulted, they developed post-traumatic stress disorder. PTSD, I feel, has gained legitimacy over the past several years and is now thought of as not just an add-on, but something that can be, if you read the Diagnostic and Statistical Manual axis for how to diagnose it, it's not that hard to diagnose. It tends to be something that puts scare factor into juries. People think or associate it with Gulf War veterans and the trauma of war, but it has now been applied to sexual assault. I've had people with employment cases alleging post-traumatic stress disorder. So I feel like that may be the new TBI.
And the claim value can also be driven by the type of expert you need to defend that claim, right? So we're in the world now talking about neuropsychologists, neuropsychiatrists, neurosurgeons, brain
100%.
surgeons, basically, right? These are the $1,000 an hour experts. And close your ears, Bill. Yes, there are people who get paid more than you. But yeah, those can really, once you get to the brain, that really drives up claim value. Obviously, any type of a break, a fracture, those are higher in claim value than what we call soft tissue injuries that generally tend to heal on their own. Strains and sprains and aches and pains and bruises. And that sort of thing. But if you have an actual fracture, anything that requires surgery, those drive up claim value. I'll say just generally in terms of civil litigation. Claim value is driven by the amount of medical cost, whether it's an overinflated invoice from hospitals that are actually getting much less from health insurers. They can still quote billboard the cost, and that's the full value of what they charge for the medical services. So if somebody's got $100,000 in medical costs, that claim, regardless of liability, regardless of how bad their case is, that claim can be worth a lot more than somebody who's got a great case, but they really weren't damaged much, and they went to the hospital. They got a couple of bandages and $2,000 in medical costs. So the amount of treatment, not necessarily the body part, although with a carve out there for brains, because they're our most important asset, and I hate to see TBI claims in my complaints that come in, but medical cost is the big driver of claim value.
And I feel as though, like everything else has gone up in price since COVID, the value, at least here in New York, of what juries are putting on a case has increased. I mean, I think I was doing a mediation a few weeks ago, and the mediator told me that it is no longer unusual for them to see like an ankle fracture with hardware in, maybe hardware out, up around and over the 7-figure mark. That was unthinkable just a few years ago.
All right, we got a few more questions, but I want to attack or discuss this. It seems like many of the lawsuits that I work on, alcohol management becomes an issue. Is it a dram shop state? Were people properly trained? How do they identify people who may appear to be impaired? Can you guys offer up your opinions, and I'll offer up my opinion on how important it is to manage alcohol properly?
Yeah,
John, I'll let you go.
The cause of and solution to all of life's problems, right? It's been a rare altercation case that I've seen where there's not some allegation that tries to blame it on the venue's service of alcohol. And again, in the everything you say can and will be used against you realm, I've faced allegations that, all you guys care about is your alcohol sales and driving up alcohol sales. And so you have, 300 different, points of service for alcohol, but you only have 200 security professionals. What gives? Well, I'll tell you what, having, several points of service for alcohol sales means shorter lines. Shorter lines means happier patrons. Happier patrons means fewer fights. You put people in long lines and all of a sudden they're fighting in line. So it's always put in these complaints. Everybody's responsible for what they put in their body. Nobody's pouring alcohol down anybody's throat. Yes, but there are responsibilities at the point of service in terms, and Bill, you can talk about team training and whatnot, and tips training specific to the alcohol concessionaires. Sure, you shouldn't be over serving folks, and you've got to know the signs. This person's stumbling, this person's slurring their words, this person's, needing to be held up by their friend or whatever. And that's something that is part of the training for your alcohol service professionals, and as well, for your frontline staff. But, at the end of the day, for me, it's a double-edged sword. I'm careful what I do with that, but it's, you can usually establish that the patron themselves had a lot more to drink than they'll admit to. And B, they didn't always get all the alcohol that they did have at the venue. There's a lot of tailgating that goes on, and it's outside the control of the venue if it's not on their property. But you do have to keep in mind, are you letting folks in? Do you have some training for your frontline professionals at the entrancing stage? You got to be careful who you let in and how drunk they look. But it's an age-old problem. It's going to be with us forever. Americans love their alcohol. Everybody in the whole world loves their alcohol. What am I talking about? It's a double-edged sword. It can be a bad fact for a plaintiff, right? Oh, well, you went in there, you got drunk, you slapped some lady's butt, and their boyfriend kicked your butt. You got what was coming to you. You dummy. You had too much to drink. Or they could say, well, geez, venue. This guy was already stumbly. We saw surveillance video of him, an hour before this fight, and he was stumbling around and arguing with people, and you still served him more. It can go either way, and it's always there in these altercation cases. I will say, outside of slips, trips, and falls, which are by far the most common claims that we get from any particular show, venue, game, whatever. If you're talking specifically about negligent security litigation, altercations are by far the most common. And I don't know, 90%. I don't know if I've ever seen an altercation case that didn't in some way reference alcohol as a factor. And this venue lets people get, drunk and tries to get them too drunk, and all they care about is making money off of alcohol. And you should, God forbid you get a case where there's some basis for punitive damages. Now they're going to measure the amount of punitive damages. Your plaintiff's counsel is going to say they made, $600,000 in alcohol sales in that month. You should hit them with that and punitive damages or whatever. It can become, an issue in that way too.
Okay, we got a few more questions. We're coming up on the end here, and I just want to get these questions addressed. The last thing I'm going to say, Eugene Posey just said, hey, you guys and gal are awesome. Thank you for putting this together. Can we use some more of these? Well, I'm going to leave it up to Lou. I'm going to leave it up to Lou and Chris. And I know that my partners are more than willing to do it, Eugene. Thank you for the compliments. And I think we'll pursue this some more. But let me cover these questions if I could. Sydney asked a question, or Cheryl, I'm sorry. Stadiums have lots of security layers. However, what about festivals and concerts? Do the same rules apply? Many festivals have bare minimum of security. Well, I can't comment on whether many festivals have bare minimum security, but I believe that every venue, I don't care if it's a bar, a restaurant, a performing arts center, a convention center, stadium, an arena, a racetrack, that they have to take reasonable efforts. Have people that are hired properly, trained properly, and staffed properly. We do there is a duty of care to make sure that we do the best we can to take care of those fans in a safe and enjoyable environment. Any comments from Carla and John?
I think this goes to your
Keep it short.
I think this goes to your non-delegable duty. If you're a venue owner or operator, you may have, whether the festival brings its own security or not, you may find yourself having some duty of care. And this will go to a frequent theme during this podcast, which is the importance of contracts and insurance. Be able to take it off of your shoulders and put it onto either that festival operator or its security contractor. John?
Yeah, and I'll just, one last thing is the one standard I see most frequently is that NFPA 250-to-1 ratio standard. So whether you're at an enclosed stadium in the middle of New York City, or you're spread out in the woods at Bethel Woods at a music festival, you'll see that standard applied. Account for it. And know how many folks you've got coming in your doors, know how many folks you got sneaking in through the woods if you don't have, the perimeter closed off, et cetera.
All right. Donna's attendee asked a question about what about the patrons return to the venue? Lots of documentation needed. I think I'm assuming that it's somebody who's been ejected. They've been told not to come back until they're allowed to come back. And there's lots of documentation. Listen, we see this at MetLife Stadium. We actually look for individuals who don't go through the process of getting readmitted. And once they do, and we do catch them, I always say, if you're stupid enough to get kicked out of a venue, then you're probably stupid enough to come back and get caught. We catch them, and now they get trespassed. Now they start paying $1,000 for trespassing the venue. So I hope, anonymous attendee, that answers your question. Jason Adams, can you speak to the responsibilities of venues to understand backgrounds of guests? For example, with human trafficking being a disturbing trend, what type of duty does the venue bear to preemptively keep those sort of predatory bad actors out of the facility?
I'll jump on this one quick, Bill. I don't know that there is any duty. You're certainly not required to do background checks of patrons. That would be, I think a bridge too far. But the issue has come up in litigation I've had. We've had people inside a venue who were assaulted by like an ex boyfriend, domestic partner, whatever, who has a restraining order against them that maybe police were aware of. And yet they still got into the venue. It could become an issue, but I don't think there's any duty to do any deep dive background checks on patrons, unless it's somehow specifically brought to your attention, maybe from like what Bill said, a prior incident. Okay, you put somebody on a blacklist, they're never to come in your venue again, but then somehow they get in. You could have some responsibility there, but generally no duty in that area as far as I'm aware of.
Carla, I'm going to read this question, let you respond. I'm going to make a comment first, though. But if a person gets injured from a slip and fall, but they have a previous injury on the same leg, knee, should that previous injury be added in the incident report in case they want to sue the building? Well, my answer is I don't think they're going to tell you that. But I will tell you, I've read depositions, and attorneys will ask that question. If there's an injury to any part of the body, they're going to ask 10 different questions on, did you injure? Were you injured? Riding a bike, riding a motorcycle, walking, playing sports. If you've never been deposed or if you've never read a deposition, I will tell you, these two people that are to the left and right of me here, they don't leave any stone overturned. I mean, everything, they ask questions upon questions upon questions. And they have a chance to go back and ask additional questions after actually done deposing the individual. So you want to comment on it, Carla?
Yes. So just because if you do have that information, that would be great to put it in an incident report. But for the person who asked the question, I want you to understand that even if somebody already had a knee injury, an ankle injury, whatever body part, that doesn't mean they can't make a claim for an exacerbation of that prior injury. Or, how many times have we seen this, John, where the person is coached to testify at the deposition, well, the problem had really fully resolved, and here I am again, starting back at square one with a bad knee. So they can still make a claim for the damages. You should try to attack the damages as being a pre-existing or an exacerbation. And then hopefully your lawyer is able to get enough medical records and information to challenge it was asymptomatic until I fell at MetLife Stadium.
Record what kind of shoes they were wearing. That's more important. We'll find the medical records later for the prior injury, but make sure you tell us what kind of shoes they were wearing. That can often be extremely helpful.
Where pictures are important. Pictures are important. But something else we forgot to mention when you're these incident reports, find witnesses. Witnesses really, really can help your case. So don't, do everything you can to take care of the injured individual, but, teach your staff to, try and find eyewitnesses. And at the very least, if you can get a full narrative from them in a report, that's great. But if you can't, get their name and contact information because it becomes very, very valuable. Very valuable.
Yeah. I can find anybody with a phone number.
Yeah. Well, there's one comment from Rick. And Rick, I saw you contacted me on LinkedIn. I'll hook up with you and we'll have a conversation about your comment, okay? But to wrap it up, this has been a pleasure and an honor to do this. We've done this before, Carla, myself, and John at another kind of a presentation at a conference. And we talked about this yesterday about being able to offer these services to you in the future. And if it's important to you, I think you need to reach out to Lou and reach out to Chris and let them know. And maybe we can set something up. But it's been, thank you for your time. 90 minutes went pretty quick. I think we could have talked for another couple of hours. Here's some key takeaways that I think Chris will be able to share with all the participants and those who did not make the call. But, we're here to help. I know how hard the venue managers work out there to provide a safe environment And I've learned a lot, and we're here for you. So I'll turn it over to Lou.
Well, Bill, what can I say to all of you? Bill, Carla, and John, such an informative town hall. Important information you dispense to us that we need, especially as we look at the fan journey and all the pain points that go into it every day and try to put on a seamless event. Also remind you, I think Bill mentioned this has been recorded, and give us a couple of weeks to get this back out on our website. And if you want more of these types of town halls, please let us know, and we'll continue to work with the Bill and see if we can do that. Like to pass on a couple events that are coming forward for us down the road at the Institute. Save the date for November 9th. We're going to look at that fan journey and the quest for frictionless opportunities for the fan during this new post-COVID era. So that'll be on November 9th, and it should be good. In February of 2023, at the Mercedes-Benz Stadium in Atlanta, and I think John talked to it a little bit today, industry standards and looking at the whole fan journey and looking at some best practices that we can bring experts in to discuss will be what we'll feature in February 2023. So we'll get more information out to you pretty soon. And then our conference is July 9th to the 11th of July in Indianapolis. It's the theme will be It's All Connected. We're very, very fortunate at the Institute to associate ourselves with the Association of Luxury Suite Directors. This will be a great conference to really look at the factors that go into the journey of the fan, looking from premium seating to hospitality, guest services, build design, and certainly the area that we bring into the table, the safety, the security, the efficiency of operations, and health related to the event. So this is in July. It'll be very exciting. Should be very well attended conference. And I want to thank again one more time our panel. Again, thank you so much. I'd like to thank the audience, the international audience that participate. You were very active. It was very informative. It was really a tremendous town hall. And again, thank you, panel, for everything. And those of you, I'll see you soon to the next town hall coming up in November. Thank you.